Chapter goes over estates and methods of ownership. Estates are basically the land and some like the money that a person owns, especially like kind of like when you're considering their death. Um, like this is where you would kind of talk about wills and things like that. So let's jump right in. First thing we'll go over are freehold estates, which basically means that the owner has exclusive right to the property for an unspecified amount of time. There are three types of freehold estates: fee simple absolute, fee simple qualified, and life estates. So fee simple absolute and fee simple qualified are quite straightforward if you can get fee simple absolute. Basically, fee simple absolute is this is an estate that lasts forever, and all rights that go with the property or belong to the owner. The estate can be sold, gifted, passed by will, or intestate succession, meaning if the owner dies, it can be passed to their proper heirs. Um, and then unless otherwise specified, this is usually the assumed estate. So fee simple, so that was fee simple absolute. Now fee simple qualified is just fee simple absolute, but with some conditions. Uh, and breaking those conditions mean that ownership is revoked. The first condition, there's two types, right? The for fee simple qualified. The first type of conditions is condition precedent, meaning that the event occurs before the transfer of the land. For example, if a property owner gives land to a city, uh, only if the city builds a park on it, then that is condition precedent because the property owner won't give the land unless the city has built a park on it. Condition subsequent, on the other hand, means that the event occurs after the transfer. So property owner gives the city the land, and on the condition that it will be utilized and maintained as a park. If the city decides, hey, we're not going to use the land for a park, then the owner must start a lawsuit for reversion, meaning to get back that land. So, uh, real quick, right? Fee simple absolute basically means they have all rights to the property and last forever. There's no specified time period. And usually is default. Fee simple qualified is just the straightforward is just fee simple absolute, right? The straightforward fee simple, but with conditions. And there's two types. One where the event occurs before the transfer, right? Precedent, pre, right? And then the other is occurs after the transfer, subsequent, sub, right? Like, so that's easy, the first two types of freehold estate. Now the third type is a life estate, and this is more easily understood with an example. Let's say my grandpa, he had his one of his neighbors took care of him during when he was old, right? And my grandpa was like, I really like this guy. I really appreciate that he took care of me when I was old, so I'm going to pass on one of my estates properties to him, but only for the time period of his life. So that means that after the neighbor dies, right, the property goes back to the family or goes to maybe let's say a charity of his choice, right? So that is life estate. Essentially, it is ownership limited by life of an individual. It can be created by will or a deed, and typically there's obligations of the life tenant, right? That person really has rights of physical possession of the property, rent, and profit of the land, right? But that person must keep the land in good conditions and really can't destroy that land and mess it up such that the next, like the succeeding party or the succeeding interest, cannot use the land as well, right? So that the life tenant should really take care of the land. Now, the party granting the life estate, in the example is my grandpa, holds revisionary interest, and there's something called the remainder interest, which is basically the person or organization, right, that receives the estate on the death of the holder. So it would be, in the example earlier, it would be the charity or my family, right? After that guy, the neighbor dies. So that's three types of freehold estate, right? Fee simple absolute, fee simple qualified, and life estate. Now, there's another type of estate, right? Less than freehold estate, which are basically leases and rentals. Um, the lease and rental agreement is considered as personal property, and then some terms. Their leaser is, you can think of like the person giving the right, right? And then the leasee is the person who's getting these rights. So leaser, right? Giver, right? Is the landlord. Gives the right to exclusive possession and the use of property to the leasee or the tenant. Maybe leasee is kind of like you have the two E's at the end, and tenant has the E. Um, Reversion is the right of the leaser to receive possession of the property after the lease term is expired, which is right basically true, right? After you lease for apartment for a year and you want to give it back, the apartment manager or building has the right to take the property back. Their leasee has the type of estate that leasees have are leasehold estates. And there are four types of leasehold estates. Estate for years, estate for from period to period, estate as sufferance, and estate of will. Um, Estate for years is kind of misnamed in the sense that it doesn't necessarily need to happen in years. This is essentially any lease for a fixed duration, right? It Whether it's a couple of months, a year, 2 years, 3 years, multiple years. These are all estates for years, as long as there's a fixed duration, and the term and the estate for years automatically terminates at the end of the agreed term. Um, and uh, One thing to note about these estates is that, like if you rent, right, the person who's renting, the leasee or the tenant, can lease may be able to lease it to someone else unless specified in the agreement, right? The leasee that then becomes the subleaser, and the person who's renting or leasing from the leasee is the subleasee, and that subleasee can not possess greater right than the subleaser. So you can kind of think of like there is the landlord, and then there is the tenant, and the tenant rents it out to another person who would then be the subleaser, and that person, uh, sorry, the subleasee, and the subleasee will never have a greater right than the tenant, who in this case would be the leasee and the subleaser. Yep. So stay for period to period is essentially month to month, right? Uh, or I guess there is year to year. Um, Essentially, there is no fixed duration for how long the lease will happen. Um, it's continues from period to period. Stay at will. So stay at will is an interesting case because we usually don't see it anymore, simply because of the nature of paying rent, paying for a specific duration of time. Stay at will basically says that there's no fixed duration and can be terminated at any period of time by either party. The law requires a 30-day notice of termination by either party, but either party can terminate at any time. Estate at sufferance is when the leasee or the tenant took possession under a lease, wrongfully retains possession of the property after the lease has ended. So you can kind of imagine a tenant uh, has a 1 year lease, the year's over, and the tenant still retains possession of the property despite the lease being over. Um, Yeah, so those are to recap, we have less than freehold estate, which is essentially talking about leases, and there are four types: year, estate for years, estate from period to period, estate as sufferance, and estate of will. Um, yeah. So now we're going to talk a little bit more about leases. This lease essentially states condition that the tenant may occupy and use the property and the term of occupancy. Uh, it serves really two purposes: conveyance of estate and contract. The elements of a lease include identification and capacity to contract. So both parties, right, must be named on the lease. So the person who is the landlord and the tenant must both have their legal names on the lease. And the parties should be of legal age and not suffering legal disability, which means like duress or sound of mind. Um, there's adequate description of the premise, like where the property or the unit has to be adequately described. Agreement of parties on terms, conditions, and covenant. That's basically saying that the parties should agree on the conditions of the lease. Consideration and duration. So consideration is essentially rent, right? The amount of rent that is paid for the lease, and the lease term must be stated. So in California specifically, agricultural leases have a max of 51 years. Urban leases and all leases really have a max of 99 years. So that's 51 and 99. 51 for agriculture and 99 for basically all leases. Um, now, elements of the lease also include rights and obligation, the legal purpose of the lease. For example, uh, the leasing a property or for illegal activities like gambling is uh, won't hold up, right? Like the illegal activity is not something that the law will uh, protect and just recognize, right? So the purpose of the lease has to be for legal purposes, and the leaser must execute, meaning that the landlord or the owner of the property who is leasing it out must um, must sign it as long as the leasee or the tenant moves in and takes possession of the property, that counts as their agreement. So again, elements of lease, identification and capacity to contract, adequate description of the premise, agreement of parties on terms, condition, and covenant, consideration and duration, rights and obligations, legal purpose of the lease, and leaser must execute. Um, statute of fraud. Any lease that is not fully performed within 1 year must be in writing. Any alterations to the lease terms must be in writing. Otherwise, lease or alterations may be unenforceable. So just kind of rules that apply to leases, and make sure to have changes to your leases in writing. Um, and if it's not performed within a year, make sure to have that in writing as well. So that kind of goes over leases and estates in general. Let's talk a little bit more. Let's talk a bit about titles, and which kind of continues estates, I guess. Um, yeah. So titles, there are different types of titles, right? All elements constituting proof of ownership, and that's what the purpose of the title is for proofs of ownership. So it's anything that is a help that constitutes proof of ownership. Um, when all the rights are owned by a single entity or a person, that is the term to use is severalty. Severalty. Um, and then concurrent ownership is ownership by two or more people. This is where it gets, there's like multiple types of concurrent ownership. So there's tenancy in common, joint tenancy, community property, and tenancy by entirety and tenancy in partnership. There's also co-ownership as well. We will go over all of these. Um, so tenancy in common. Basically, this is the default concurrent ownership method. Co-tenants can have unequal shares, but have equal use and possession. Each owner may sell or transfer or will his or her interests separately from the other owners. Partition suit is basically when an owner can apply to court for the property to be sold and that the profits be split and divided proportionally to ownership. Um, so yeah, so this is pretty flexible for all of the owners, but any owner, right, can go to court and apply for the property to be sold. Joint tenancy is when two or more people own the property together with right of survivorship, meaning if the owner dies, his interests are split among survivors. There is no new deed or probate required for transfer of ownership. Um, yeah, essentially, yeah, yeah. And then there's four unities, right? They share equal interests. They grant title by the same instrument, obtain title at the same time, and have equal right to possess the property. So tenancy in common and joint tenancy. Now, community property is when is essentially husband and wife, uh, property acquired by husband and wife during a valid marriage. So there are a couple of exceptions, like gifts, bequest, device, or descent, um, that can be counted as separate property and as long as it remains separated. But any property acquired by the husband and wife usually is considered community property. What this means is both husband and wife need to sign off on encumbrances, leases of at least 1 year, uh, and this also means that husband and wife are both responsible unless one spouse owns a community personal property business. They're responsible for the debts before and after marriage, uh, except for the earnings of either spouse. Testate, death with a will, intestate, death without a will, and the states using community property are California, Arizona, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin. The other states use tenancy by the entirety. And that's what we'll go over right now. Tenancy by entirety is owner must be husband and wife, right? Neither owner can sever his or her interest without the consent of the other spouse. And the interest cannot be reached by the creditors. So that's the two. Community property and tenancy by entirety are really focused around the property owned by husband and wife. And in California, the one to focus on is community property because that is the one that's practiced. Um, yeah. All right. Let's talk about tenancy in partnership. So this is talking about partners who own property for partnership purposes, and they enjoy equal rights and can be non-equal owners. Each partner shares equal interest in income. If a partner dies, the other partner gets title, but only for the purpose of winding up partnership affairs. They can technically not be concurrent owners because they can be owned, like it can be owned via a corporation. So if the corporation owns the property, then they don't necessarily, then the property is one entity, right? It's not uh, a single entity that owns the property and severalty, which means that it's all rights are owned by a single entity or person. Concurrent ownership is by two or more. So technically, tenancy and partnership can be doesn't have to be concurrent ownership. Um, so that is tenancy and partnership. Yeah. And then let's talk about co-ownership. So these are kind of like places that have that are owned by multiple people at the same time. Um, One place is like in condos or condominiums where there is separate ownership for particular units, but there's a common area. Condominiums can be industrial, residential, or commercial. There's a stock cooperative where uh, that owns property for the sole purpose of providing housing for shareholders. The corporation or association holds the title and severalities, kind of like what I was saying earlier, where the single entity that owns the property is corporation or an association. And how this works is each share entitles the owner of the share to exclusive use of one of the units under a special kind of lease. So that can be like a proprietary lease. And what that means is essentially they have more rights than a regular renter, but less than an owner. So it's technically leasing, and the way they kind of sell the or transfer the ownership is to sell the share, right? Because the share is what entitles the owner to the use of the unit. And these stock cooperatives are managed by a board of director, very similar to like a company, where a board of director is would manage the company, um, or I guess oversee the company. Um, Owners of shares pay their proportionate amount of mortgage and tax. Now, if so all of the owners of the shares pay their proportionate amount of mortgage and tax, right? But if any of those, if a single owner, right, decides they will not pay their mortgage and tax, then the other owners will need to cover it. Otherwise, the property may be foreclosed. So that's where it kind of gets, I guess, a little bit risky. There might be other conditions that I'm not aware of, but from what I've read, it seems like everybody needs to cooperate. Maybe the corporation has some funds to cover it in the case of this happening. Um, so that was stock cooperatives. And then the next thing we're going to talk about is limited equity housing cooperative. This is essentially a stock cooperative, but for low income families and focused on providing housing for low income individuals. So another type of co-ownership is planned unit development. So this is very similar to a condominium in that the units are owned in severalty. So the units are owned by individual owners, and there's a shared area. But the difference is that the owner of these planned unit developments owns the actual land rather than the unit. Uh, Common areas are recreational and landscape around high density housing. And this is usually made to meet high demands in housing. There's an HOA, and the HOA can enforce obligations that become liens on the property. And the final type of co-ownership is town shares. The person gets rights to share the condo or multiple unit development during specific times of the year. For example, if there are like let's say there are you split you own a property or you timeshare a property with some friends, right? That means you can get the property during winter, your friend can get it during summer, another friend can get it during spring, and the last friend would get it during fall. And the number of people owning is the number of intervals, and the interval being like, for example, the season, right? Fall, spring, winter. It could be in months, could be in weeks. But this is essentially giving the person right to share condo or multiple unit developments during a specific time of the year. If there are 12 or more timeshare owners in a given project, the Subdivided Land Act applies.